There are so many things that happen in our system that are avoidable with planning. So consent incapacity is a topic that I love to talk about. It's interesting, it's informative, but it is also very confusing. Consent incapacity is so confusing. I lecture at York University, and the class on consent capacity is 3 hours. For my class in 3 hours, we don't even scratch the surface, really. It is very confusing. Which leads me to my obligatory disclaimer. I really hope today is useful, but please don't rely on this as legal advice. It's actually just too nuanced. It's too easy to get it wrong, and as you've already started to hear from the day, the cost of getting it wrong can be significant. It can be tens of thousands of dollars for getting it wrong, so don't guess. This area of law is a lot like medicine. Prevention and being proactive is way better than being reactive. So planning saves you a great deal of time, stress, and money. So why do I care so much? Other than hearing that I'm a lawyer, that really doesn't tell you much of anything. So I'm a health lawyer. My focus is called family health law, which I coined that. And the reason it's family health law is my clients are mostly family caregivers. The theme of what I do is I help people create and protect their families. So I actually started my career in health law because I was passionate about health law, and I worked at a firm advising hospitals and long-term care facilities, and I loved that. But I did start to notice this significant gap of the family members often acting as substitute decision makers in the hospital, and no one was advising them. No one even said, hey, this is actually a legal problem. Maybe you don't realize it. You're in the middle of a legal problem. You could seek advice here. You have options, you have rights, you have obligations. There just was this gap. And everyone but the family members had access to legal. The hospitals, the doctors, often the patients did, not the family members. So that was sort of the light bulb moment of transitioning to doing what is family health law. And why I care so much is because this is, I mean, the families, I'm sure you heard all day today, and you've all lived it. The family caregivers really are the backbone of our healthcare system and are often placed in tremendously difficult situations. And they deserve a voice too. They deserve advocates, they deserve guidance, and shouldn't be alone. And in doing this work, there are two words that come to mind all the time that ties me back to the piece about planning. Those two words are if only, and I think them all the time. If only this family had received advice, if only this person had made a power of attorney, if only this family had not thought the worst of each other and had a family meeting early on. There are so many of those if only moments where I look and I think this terrible problem that you're in really could have been prevented or at least minimized with planning. So what I hope today is to cover sort of three main things. One, I want to explain capacity a little bit more. It's a word that gets thrown around a lot. I'd like to bring some clarity because the significance of it is very important. So we'll talk about capacity. We will talk about how you can actually plan. So powers of attorney we'll talk about in some detail, but beyond that, what else can you do to plan? Also, what are the consequences of not planning? Because sometimes that's the motivator to get planning, if you can see what might be coming down the road. So before we get into the legal part about capacity issues medically, they come from somewhere. Dementia is obviously one of the big ones that I see. It's not the only one though. There are other causes of incapacity, and incapacity can happen, it can strike it to anyone at any time. I mean, incapacity can happen from delirium, it can happen from a traumatic accident. People can become incapable from all kinds of things. So really, all of us should be planning. It's not just if you're a caregiver, it's not just if you're a senior. I have powers of attorney that are very detailed. If anything happens to me, my power of attorney is unusually detailed because I do this. One of my pet peeves is guardians. People think about their kids in their will. They have guardians. No one puts it in their power of attorney. It's a pet peeve. So my power of attorney says, if something happens to me and I'm in a coma, who's watching my kids? Hopefully my husband, but we could have been in the same car accident. So young people too, pass that on to your kids and your grandkids, and if you don't have them for yourself, the planning is not just for ill or elderly. Every adult should have a power of attorney and have some aspect of legal planning for themselves. But the key message is now is the time to plan. If you haven't done so, now is the time while you're capable and maybe while your loved one is still capable. That's huge. You can save a lot of the stress and the tens of thousands of dollars of people fighting in court if the planning happens now while the person, whoever that person is, while they are capable. because once capacity goes downhill, it's really hard, often impossible to correct course. So what is capacity? This is where I'm fighting my urge to wander and use gestures because it's so complicated that I get, I start using my hands a lot when I talk about capacity. It is not, there's no global incapacity. In Ontario, our legal system doesn't say you're capable or not. That's actually not how it works. Our system is, our legal system is very much designed from decisions that have been in court to our legislation. It's designed around empowering people to make their own decisions. So upholding autonomy, because we all want to make our own decisions. We don't want that power taken away from us easily. I assume we all agree probably. We all want to make our own decisions as long as we can. So our law recognizes rather than one concept of capacity, we have different categories of decisions. And for these different categories, there's different types of capacity. So a person may call my office and say something about their parent or spouse is incapable, or a doctor says they're incapable. My question, I answer with a question. Incapable of what? Incapable of what? They have dementia? Okay. They may be capable of everything. They've been found incapable of managing property. They may be capable of making treatment decisions. These different categories exist in law, and with each of these kind of buckets of decisions, there's different laws that apply, different laws that tell us who decides, are they capable? You may be a spouse or a child. It doesn't mean it's actually your decision or your call to say this person is now incapable, trigger next steps. The legal test that has to be passed, there's actually different standards in law. It may not surprise you that managing money is a higher standard of capacity than making a decision about, do you want the flu shot? Those are the very different kinds of decisions, and so the test for capacity is different. So we have all these different types of capacity. To make it more confusing, it can fluctuate. Sometimes capacity is gone and it's not coming back, or it's on a one-way trajectory, but it can fluctuate. Medication side effects can make people incapable, or certain times of the day, like with dementia, there are some people that have certain times of day where they are more lucid and better than other times of day. It's a moving target, and yet so much flows from incapacity. It can actually be so complicated to figure out if someone is capable. So the question is always incapable of what? And then from there, the conversation flows. Are we talking about money, treatment? And then that lets us figure out what's the test, who makes that decision. So capacity, though, generally speaking, it's the prerequisite for decision making. A person must be capable in order to make their own decisions of whatever category we are discussing. It doesn't mean they have to make good decisions. This is where I see family members often upset, and a very classic example is mom refuses to go to long-term care, or dad, or spouse, or whomever. Won't go. She's had 3 hip replacements and done the rehab and the surgeries and been through it. Why, she needs to go to long-term care. Clearly this isn't safe. How can she continue to stay at home? And the question that I always have to ask as well, is she capable? And there are professional capacity assessors that weigh in on that. It's not my decision. If she is capable, she is allowed to take that risk. Now, an assessor may sit down and probe, do you understand what the risk is? Why would you stay at home when you've had 3 hip replacements? How are you going to get groceries? What are you going to do if you have a fall? At the end of the day, though, that person may actually be able to demonstrate they do have insight and they don't want to go to long-term care. Guess what? If they're capable, that's their right. It's their risk to take, and they will maybe suffer the consequences from it. Our law allows capable people to make bad decisions. So as caregivers, this is where capacity can become frustrating. You sometimes almost want your loved one to not be capable, because you want to intervene to protect them. But autonomy is a big part of our law, recognizing that right to make decisions. The other part is protecting the vulnerable, and our law does a reasonable job in this area of striking a balance, of protecting people from themselves and making bad decisions. But bad decisions are allowed, staying at home. One of the earliest cases on this point was, it's older, but it's actually sticking around because it highlights the example so well. Is a woman, she was spending her money really inappropriately. She was spending in a way that was not consistent with what she actually had, buying things like jewelry. And the family said, Mom is buying jewelry when she needs to save this money. She doesn't have huge amounts of money. She's got years ahead of her. And mom said, jewelry makes me feel good. I like shopping. That's the essence of the case. And she was found to be capable, and the person who made that decision basically recognized maybe not a wise decision, but if she's capable, that's her right to make a decision, and she will maybe be the one to suffer the consequences. So that is at the heart of capacity laws, recognizing first comes capacity, then comes whatever the decision is. We actually don't legally work backwards to say, judging the decision, it was a good decision, therefore the person's capable. That would actually be legally backwards. It's incapacity or capacity, and then if they're capable, they make their decision. Again, of the category we're talking about. It may be that they are capable of some categories and not others. Most areas of life fall into personal care or property, which we'll talk about. There are the odd decision that kind of has no legal tests at all. So what happens when a person is incapable? This actually all ties back to what kind of incapacity are we talking about? So I'll start with the easy one. The easy one is treatment decisions. So doctor says spouse needs to have, the doctor recommends some kind of treatment. If a person is incapable, the law tells us exactly who would make that decision. So this is easy. The Healthcare Consent Act actually has a list. No paperwork is needed, nothing special has to happen. Our law has a list, and it goes from top to bottom, and the doctor can literally identify, does this person have a guardian? Do they have a power of attorney? Do they have a spouse, kids, etc.? And if they have nobody at all in their life, the government will step in, Office of the Public Guardian and Trustee. So all of us automatically, if we have not made a power of attorney, we all have a decision maker automatically if we are incapable. So that covers treatment decisions, personal assistance service, and actually admission to long-term care. So if someone's at a point they've declined, they have some sort of capacity issues and they've lost capacity, their substitute decision maker for long-term care, it actually just happens automatic if they do nothing. So if someone doesn't plan in that area, there can be other reasons why that's not a good thing, but the law does step in. Here's where it gets much harder though, money. When I got married in 2011, I called my bank, and I had been a lawyer for all of 3 months, so I didn't yet know what I know now. I called and I said, hey, I got married. Just wanted to be a responsible adult and tell you because my husband's name should be in my file should anything happen so he can access my money. And if something happens to me, he probably would need that. I'm probably not able to work at that point. Seemed like a good idea. And after all, don't spouses automatically get access to their partner's bank account? I thought. No, they don't. There's no automatic decision maker for property, not even your spouse. And so the person on the phone said, I can write his name down, but it won't do anything. We have no authority to give him access to your money. And this was a bank account that I had before we got married, and we wanted to keep them separate and joint, and as some people do, and he has no access to it. So she said we would need some kind of legal authority. So that's when I knew enough to say, oh, you mean like a power of attorney or guardianship? Like, oh, I guess I do need to have a power of attorney, because often so many people think you do it later in life, you do it with your will. As a 20-something who's married, my husband had no access to my separate bank account. Or if had I happened to own a condo before we got married, any property, he had no access to any of that legally. So that is why on the property side, it's particularly important to plan. And we'll go into even more detail in a moment. So what can happen if you don't plan? So maybe I'll pick up, because I'm already on that example, the decision maker gap. So if someone is incapable of managing property, and that can happen from something sudden or a progressive illness, if someone becomes incapable and they don't have a plan, they don't have a power of attorney for property, there is now a gap. And that can be a really big problem. I actually had a client, her mother did not have a power of attorney for property, lost capacity, and was not paying her bills, which kind of goes hand in hand sometimes, not paying her bills. And she was very worried. It was winter. She was worried her mother would lose heat. She was well enough to be living home. There was another, for at periods of time, someone living with her. At times she lived alone. She didn't need physical help. It was actually, in that case, mental illness. She was worried her mother would lose heat. She was worried her mother would give away possessions because she just became really generous sometimes. She was worried about real estate agents who, when the market was doing what it was really doing a little while back, real estate agents were knocking on people's doors. They knocked on mine. She almost put the house up for sale for very undervalued. She was worried about all of that, but there's no power of attorney. She could not take action, so she had to become the guardian of property. Well, I do guardianship applications for clients, so that's what we did. But guess what? It doesn't happen overnight. It doesn't even happen in a few weeks. Usually it takes a couple months. And that's if the family's not fighting. Whole different story if the family's fighting. It can take months, so there's a gap. So she was paying out of pocket herself, trying to keep mom afloat, mortgage payments and bills and other things. Completely unavoidable. You can imagine the stress that she's under. She's working to pay her own bills, stepping in for mom, caring for mom. Avoidable. Mom had a house. House was worth a good amount of money. The money was there. She's living in poverty for no reason. Her mom has the money, and she just didn't make a power of attorney, and it takes time to get a guardianship application put together and filed in court and all the steps. And there are ways to sometimes deal with it out of court. I don't think we need to go into those details, but it can take time. It does take time. It's not an overnight thing. Powers of attorney can be done in a way that it's automatic. It can be done that when someone's incapable, immediately transitions over to the person who's appointed, and there's no gap. And we don't have to worry about mom losing heat in the winter. So the family conflict, I think you've already heard some great examples. I see the same thing, unfortunately. Failure to plan puts children in a situation where they are fighting like children. So if you are parents and thinking about appointing your children, think back to them being their most immature selves when they are 7 years old, attacking each other. That all comes out again for some reason. It's like a divorce. And in divorce, when people fight in court, it's not just about the money anymore. There's just this hatred that develops in some people's divorce. It is the same thing. Guardianship lawsuits and power of attorney lawsuits are really similar to divorce lawsuits. It just becomes so personal, and that becomes very expensive, embarrassing. Very serious accusations are made. I've had clients be accused of holding someone hostage. It gets really ugly. Again, with planning, can be partly avoidable, especially with powers of attorney. What can happen if there are no powers of attorney is someone will say, you know what, mom needs the power of attorney. I'm going to print this form off and get her to sign it, and then we're good. Sometimes that's fine, but sometimes at that point, mom is no longer capable of making a power of attorney. Legally, she's not capable, or it's fuzzy. The challenging part about capacity laws, the way the law is written, you would read it and think, well, black and white, capable, incapable. In reality, as I'm sure some of you have seen, it's far fuzzier. People don't just decline overnight. Cognitive impairment can be a progression that happens, and then you kind of realize one day, maybe dad shouldn't be writing checks anymore, or maybe my spouse shouldn't have a $15,000 spending limit on a credit card anymore. It's not always an immediate realization. It can be gradual. So putting that power of attorney in front of someone without any oversight by a capacity assessor, having a conversation with them and documenting they're capable, or a health professional documenting it, or a lawyer, doing it in that sort of isolated way, questions will arise, is it even a valid document? And that can create a mess, especially when multiple powers of attorney pop up, because now mom's changed her mind and she wanted you last week, but she wants me today. Disaster. It's really hard to say, is it even a valid document or not? And sometimes health professionals and banks don't want to get involved, understandably. They can put up their hands and say, you guys can deal with it through the courts. Police sometimes will say that too when they're contacted. Get a lawyer. Well, going to court costs a lot of money. So doing an after-the-fact power of attorney while the person's already questionably capable can invite a lot of problems. So again, now is the time to do it. If the person is capable and there's evidence around it, like their doctor's notes, they're making their own treatment decisions, that's a much better place to be than after saying, well, let's try to create some evidence. Mom was having a good day that day. It's fuzzy, and it creates a lot of problems. The family conflict part is huge, and definitely there is that underlying concern that people have about either their own inheritance or a concern that their siblings or other family members, and definitely in the blended families, suspicions that other people are concerned about their inheritance. A lot of that can be resolved proactively, not just through powers of attorney, but through other kinds of planning, financial planning, family meetings to encourage open discussion and get everybody's concerns on the table. Maybe not everybody actually wants the family cottage. You know, you can just assume it and chug along, or have open family discussions about some of this stuff and proactively get it on the table. Who wants what? Who's going to do what? Who's involved? And a lot can happen in a discussion where conflicts that will arise later can be avoided through family meetings. There are professional mediators and services out there that can help have those discussions, but it's not, and sometimes that can then lead to making a power of attorney with everybody's buy-in. Not everybody even wants to be appointed as a power of attorney. Lawyers will often joke when it comes to wills, being appointed is not an honor, it's a burden. Not everybody wants it. Or some people may say, I would love to, but I've got 4 kids, I've got these other commitments. So one sibling might be fine with it, especially if the siblings do trust each other. Every family is different, but really, I can't stress enough, having discussions within the family can help make the planning a better process, because everyone's been able to vocalize what they think they may be able to do, what they want, and hopefully alleviate the concerns about greed and suspicion and someone's worrying about their inheritance. It can also be a way for someone to hear directly what's important from their loved one. Like someone might say, spend all my money on me. You know, your inheritance, you're lucky if you get some, but my money goes on me. If everybody hears somebody say that, that might make the difference. Everybody hears it together, versus making assumptions and guessing what did mom or dad want. Not just about money too. End of life decisions are terrible, terrible decisions that I've seen tear families apart. One recently was about actually, you already just got a little introduction to a feeding tube example, but a feeding tube decision about whether to remove a feeding tube from a person with dementia, and that there isn't always a right and wrong answer. There are some cases where the health professional will say, I'm fine either way, it's up to you guys. And I've seen one child say, Mom would not want this feeding tube anymore. This is torture, keeping her in this advanced state of dementia. She would not want to live like this. Other child says, removing the feeding tube means Mom will die. She can't swallow. This is murder. Torture and murder, it's really hard to find the middle ground there. And there's not a lot of splitting the difference like in other kinds of negotiation. Close siblings get torn apart and their family relationships can not always return to what they were. That could have been avoidable. Mom had dementia. It is not a mystery that sometimes some people with dementia may need a feeding tube. Mom could have talked about this with her health professionals, thought about it, discussed it with her children, documented it, and then one of them would be in a really difficult situation where maybe they're seeing something that they personally don't like. They don't like watching mom suffer like this, or they don't like the idea of removing the tube, but at least knowing that's what mom wanted makes a big difference versus fighting tooth and nail because you think you're fighting for what the person would have wanted, but guessing to a certain extent. Open conversations and thinking, when someone does have a diagnosis, thinking, what will the future entail? Talk with the doctors about it, talk with the other health professionals, have family meetings and document it. It can just do so much to avoid these situations. So we've got decision making without direction. So the feeding tube example kind of is that, is I think mom, it's never said out loud, it's mom would have wanted, but I think mom would have wanted this. I think mom would not have wanted that. It's decision making without direction if there's no plan. Or the automatic decision maker. So I said the law covers us. We all have someone for treatment, admission to care facilities, and personal assistance service. That person that is automatically on that list may not be the one that's the best person. So consider the spouses. I did recently see it. One person, she decided she doesn't want her husband anymore because he is starting to decline in terms of his health and his capacity. And she realized, I'm fine now, but if anything happens, he's my decision maker. I don't think he should be my decision maker anymore. So that person who falls automatically isn't always the best person for a number of reasons. So we can look at that list and say, I'm fine with that, but often that's not the case. So one point that often gets missed is how much planning for incapacity actually helps the caregivers. Not only does it give you direction, you're not guessing what the person would have wanted, it makes the conversations with families easier because you all know what a person wanted. It can also save a lot of stress, and from what I see, it can save lawsuits. It can avoid lawsuits and help protect people from accusations. So I'm gonna paint a little picture of a caregiver who says, I love mom, she's been amazing, and now she's at a point that she needs help. I'm gonna give up my job and move in with her. and I'll do something on the side just to make some money, but I'm going to give up my full-time employment and move in. And she seems to really enjoy my company, so I'm not seeing, doing all the activities I'd like to do, but she really seems to want me there, and she's becoming really reliant on me. I, take mom everywhere she needs to go, and sometimes she goes for tea with her friends. I make sure she's got some money available for that. I've started to help her with her finances. She asked me to. I write the checks, but she still signs them. She's fine. She's capable. And I'm here because I'm a good son and I'm a caregiver. And that all sounds like a wonderful child. And let me tell you how the sibling comes into my office. My brother's unemployed. He's living with mom rent-free. Anytime my mom tries to go anywhere, he's always by her side. He won't let us speak to her alone. There's cash withdrawals, and I think it's for himself. You see how this goes. The optics matter, and some of my favorite meetings are the people that come in early in the journey taking care of their parent, and I say, I'm so glad you came. Let me tell you all the things that you're telling me and how I could spin that, and why all the things you can do proactively to protect yourself. I'm not doubting that you're a good caregiver, but if there is conflict in the family, optics matter. Like, don't use cash and keep receipts. You can do all kinds of things proactively as a caregiver, even if not acting under power of attorney. There are a lot of proactive things that can be done that, should a conflict arise, you can defend what you've been doing and avoid a lawsuit, or look really good in a lawsuit because you've done the things proactively. Versus I had a client going back 10 years of bank records trying to figure out where thousands of dollars went. The inference that he took something was there because he couldn't prove it otherwise. So a lot can really be done to protect not just the person who has caregivers, but the caregivers themselves can get into hot water because these conflicts do happen. So a lot, thankfully, can be done proactively. But that's just one thing to keep in mind, is the benefit to protect yourselves too. So how can we plan? I think I've kind of mentioned a number of ways. We can obviously do powers of attorney. We can have family meetings. If someone has a diagnosis, talk to the health professional, figure out what's ahead and plan for it. Talk with financial professionals. Certain things like joint bank accounts that might sound like a great idea can actually backfire terribly. So having conversations with all the different health professionals for sure. Visiting long-term care homes and signing up for them early. Finding out what's important. Does this person care to be in a sort of culturally, a long-term care home where a certain language or religion is there? Or do they just want to be closest as possible to family? What's actually important? Is being in a private room so important that it's worth waiting at home an extra year? Finding out and documenting that so everybody knows those wishes are all the things that we can do. So planning for powers of attorney, I think you've already gotten a sense of it, so the fact that these apply when someone's alive, not dead, is very important, and I think you did get that message previously. So there's two types, property and personal care. Property means all property. It can cover paying bills, mortgage, selling a house. The law actually says under a power of attorney for property, you are giving authority for that person to do anything with your money except for make a will. The good thing is these documents can be completely customized. Unfortunately, people don't do it often enough. But someone could say, here's the authority you have, and here's what you don't have. Or here's the checks and balances you must report to your siblings or to my children if it's a second marriage. Or you can touch all my money, but don't touch this property, this artwork. It can be a completely customizable document. People don't do that often enough. But the reality is, without instructions, someone has access to make any decision with the property, anything at all, other than make a will. On the personal care side, that covers everything as well for personal care. Healthcare, shelter, nutrition, hygiene, safety, clothing, all of that. So if someone does not go into detail, a person now has authority for any category of that that the individual is not capable of making. That's a lot of power. We sign these documents and they are so powerful, and I see them regularly. People come into my office and they are done poorly, to be honest, incomplete and poorly. They are regularly not leveraged in all the ways they could be. Sometimes they are invalid and people end up having to go to court over that. Witness didn't sign. Invalid. Thousands of dollars later trying to get it declared valid. So there are so many things that these documents can do. I've had a client actually say, I want certain soap used. And she actually used the phrase, look good, feel good. She said, my kids will know what it means. Put that in there. This is part of my wish. So I've had clients say, one client, she wanted things to be fun. She wanted to have a binder of things popping up at people about her wishes. They can be really useful tools, really customized tools. Like I said, for myself, I've decided who should be guardians in my power of attorney, because my will would not take effect. They can be really creative documents. And end-of-life wishes. The terrible boilerplate language of no heroic measures has become a real problem in law. People were putting that in and still are putting that in. And then the time comes and it's, what's a heroic measure? They wrote that in the 80s. That's now routine surgery. That's not heroic. It's not experimental. What were they thinking when they put that standard language in? It's not helpful. So end-of-life wishes about when someone would want life support withdrawn, that's a really big one that comes up. All of that can go in these documents. So it's a bit of a pet peeve of mine how underutilized these are. And also, I heard someone said there should always be 3 people. Sometimes that's great. Sometimes that's actually a problem. It's too many cooks in the kitchen. It's completely customizable. People can make tiebreaker clauses. They can create veto power. Unfortunately, sometimes they do that and they all contradict each other. Because as I had recently with 3 children, it was majority rules, and there was unanimous and majority rules and a tiebreaker clause with 1 person. So it's either 1, 2, or 3. We weren't sure. And obviously you can imagine they each picked the interpretation that favored themselves. So they should be worded carefully, but they can be leveraged, because without tiebreaker clause, sometimes people end up having to go to court. As simple as that one sentence of a tiebreaker clause could have saved them from going to court. So proactive, not reactive. So it's not, almost anyone can be an attorney. The requirements legally are quite minimal. There's an age requirement. There's not a lot more. They have to be mentally capable themselves. You should, or to act rather, at the time, if they aren't capable, they could not act. But there's not a lot of limitation, which means there's no obligation to pick a spouse, especially if the spouse's health is declining. I've had clients, they say, my dad has been appointed, but he doesn't want to act. He's got his own health issues. He'd rather us do it. No obligation to pick spouse or the kids. It can be really anyone that is trustworthy, that is willing to follow wishes even if they don't agree with them. Who is willing to be collaborative and transparent and respect confidentiality. Someone who's responsible. Someone who's gone bankrupt several times may not be the best person to appoint for property, even if that son was going to be offended when you don't include him. So there's a lot, and actually I won't go into too much more, because the Caregiving Matters did a whole power of attorney series, and so you can listen. The Caregiving Matters has so much information about powers of attorney. The podcast I did was all about the topic of joint, basically the pros and cons of picking one person versus more than one. That alone was a podcast. So there's so much information. Do go and on the website, because that project was phenomenal, and will really help you and your loved ones pick. But the point is, do it. Do the exercise.